Hello, everyone. Welcome to week 12 of Constitutional Law. This is our very last lecture for the semester. This is a little bit of a different lecture video, whereas in the previous lecture we looked at the, I suppose, more doctrinal or generalized ideas about constitutional change and how we might amend the Constitution. Given the context of the upcoming referendum on establishing a First Nations voice to Parliament on the 14th of October, I wanted to do an additional lecture video that talks through some of the specifics of the voice referendum. What is it? What's proposed? How might the campaign play out? And how can we use it as a case study to deepen our understanding of the topics discussed in the previous lecture video. So an opportunity to look at a lot of these ideas in practice, hopefully also a bit of an educational resource for you, something maybe that you can share with friends and family as well. Maybe they won't want to watch a half an hour lecture video, but some key ideas around what the voice is and better understanding the proposed change to our constitution. So let's get into it. So in today's video, what we'll cover is a very brief outline of the history of proposals to change the Constitution to recognise First Nations people. This voice idea hasn't come out of nowhere, and it's important for us to understand where a lot of these ideas come from. We'll then unpack specifically what the proposed voice is and correspondingly what it's not. We'll talk through the constitutional reform process, tying back to some of the key ideas that we've talked about in the general lecture. And then we'll discuss the referendum campaign and give an overview of what the yes and no arguments are putting forward. So hopefully by the time you vote in the referendum, you'll be able to make an informed choice that reflects your views and your perspectives on this important national issue. So let's begin by thinking about calls for recognition of First Nations people in the Constitution. Historically, the perspective that we're coming at this from is that First Nations people were deliberately excluded from the Constitution at the outset. There was, and one of the key things that the 1967 referendum did was actually take some steps towards including First Nations people back into the Constitution. It's often mistakenly believed that the 1967 referendum gave Aboriginal and Torres Strait Islanders the right to vote. That's not quite true. They already had the vote in many instances, and it even took later than the referendum to formalise that vote in some contexts. But what the 67 referendum did do is make two changes to the Constitution. The first was to Section 51, paragraph 26, sometimes known as the races power, which previously provided that the Commonwealth could make laws with respect to, remembering all our heads of power discussions right back at the beginning of the term, power to make laws with respect to the people of any race other than Aboriginal people in any state, and the amendment removed that wording. And so what that meant is that the Commonwealth government was able to make laws that were specifically targeted at First Nations people. The second change, and this is one that maybe is more widely recognised by people, is that it removed Section 127 of the Constitution, which had previously provided that in reckoning the numbers of the Commonwealth, so in things like the census, that Aboriginal people were not to be counted. Section 127 was removed as a result of the 67 referendum, and so they were able to be counted in the reckoning of the population. But while those were, I suppose, important steps to address some of the exclusions of First Nations people, they certainly didn't really do much of substance. And so for a long time, there have been calls to do more. And there have been a few attempts and a few other discussions. So in 1999, which is famous for the Republic referendum, There was also a proposal to add to the preamble of the Constitution, which included a recognition of First Nations people. So I've bold the text here is the full proposed changing, which was rejected in the 99 referendum, but I've bolded here the section that related to Aboriginal and Torres Strait Islander peoples and recognising their status as the first inhabitants of this land. But as I say, that was alongside the Republic. This was a proposal that was rejected in 1999. Since then, there have been a range of options considered. In 2011, there was an expert constitutional panel that considered and consolidated a lot of the different calls and different ideas. Some of the main ideas that they considered was to revisit the preamble. The part of the issue and discussion there was that this is a symbolic change, and adding a preamble that recognizes First Nations peoples would be important symbolically, but it doesn't necessarily offer anything of substance. And when we consider that things like the Closing the Gaps reports indicate that First Nations people in Australia have empirically worse outcomes on a number of domains: educational, health, mortality rates. The sense was that doing something symbolic really, or purely symbolic, really doesn't do anything to close the gap or address these inequities. So that was an idea that the expert panel didn't necessarily recommend. Another option that was considered was to change some of the other, I suppose, racial provisions in the Constitution. So, for example, Section 25 allows for the disqualification from voting on the basis of race. It acknowledges that a state government could disqualify a class of people from voting on the basis of their race, and that in turn would restrict a person's ability to vote at the Commonwealth level as well. In substance, Section 25 doesn't really operate anymore because of the Racial Discrimination Act. If a state parliament were to try and pass a law restricting someone's right to vote on the basis of race, that would probably infringe the Racial Discrimination Act. It would be inconsistent. And so thinking about our Section 109 inconsistencies, that would be, it's unlikely that a state would be able to pass such a law in practice. So it means that Section 25 doesn't, in practice, really operate anymore. So there have been calls to just remove it. But at the same time, it sort of, because there's no practical substance to it, there's the sense that, well, okay, it doesn't actually really do anything to close the gap or improve outcomes or take a substantive step towards reconciliation. The other option was to take another look at Section 51, paragraph 26, that a power for the Commonwealth to make laws with respect to the peoples of any race. There were some suggestions to simply remove that power altogether, or to amend it so that the laws that are made can only be for the benefit of First Nations peoples. A somewhat similar proposal was to insert a prohibition on racial discrimination into the Constitution. Part of the difficulty with both of those proposals that the expert panel looked at was that in all of this, the importance of acknowledging First Nations people's perspectives and their ideas around self-governance were missed out. So, for example, a law that can only be made for the benefit of Indigenous Australians is really problematic in practice, because from whose perspective does for the benefit mean? And you've looked through your assessments at the stolen generations and the policies that led to removing First Nations peoples from their homes. There was a view that was, by the government, there was a view that was for the benefit of Indigenous Australians. So the suggestion that adding a clause in that laws could only be for the benefit there's an argument that it wouldn't actually prevent harm or necessarily do much good. And so what the expert panel really honed in on was this idea around amending the Constitution to improve governance and political participation by First Nations people, to take steps towards ensuring that government is able to better understand the perspectives of First Nations peoples and allow First Nations peoples to more effectively participate in government and in policy making that affects them. And so that then in turn has led to calls for a First Nations voice to Parliament. So there was really clearly outlined in the Uluru Statement from the Heart in 2017, which called for an Indigenous voice, and has since been formalised into the proposed change to the Constitution that we'll be considering in the referendum. So the voice proposal itself, I've got here the wording of a new section 129. This is the change that's proposed to be made, which includes recognition of Aboriginal and Torres Strait Islander peoples. There shall be a body called the Voice. The Voice can make representations to Parliament and the Executive on matters relating to First Nations peoples. The Parliament shall, subject to this Constitution, have the power to make laws with respect to matters relating to the Voice, including its composition, functions, powers, and procedures. So what does that mean in practice? It means that the Constitution would establish a new institution called the Voice, and as an institution, it would be protected under the Constitution. It couldn't be removed. It would have the certainty and the recognition and the value that is bestowed on institutions that are included in the Constitution. However, the specifics are left up to Parliament. So that third clause around Parliament giving a head of power to Parliament to make laws with respect to the Voice, and in doing so, decide exactly, how members should be chosen, what the processes should be to enable the Voice to make representations, the procedures that it should be following, all those sorts of things, which are likely to need to change over time, right? And we'll look at some other examples in a moment. But these sort of more operational matters are not things that you necessarily want enshrined in the Constitution itself, because it means that if circumstances change, or if the way that the Voice works needs tweaking down the track, Parliament can just get in and fix it, rather than having to go back to another referendum to make that change. So there's sometimes discussion about whether the level of detail that's included in the Voice in this proposal is appropriate. And when you look at it from a more practical perspective, in terms of the raw constitutional change itself, it probably strikes a really good balance. So we could compare it, let's say, to Section 71, which establishes the High Court of Australia, another really important institution. It provides that judicial power of the Commonwealth is vested in the High Court and other courts that Parliament may create. So again, acknowledging the role of Parliament in adapting these institutions over time as they need to, and that the number of judges shall be not less than 3, so a Chief Justice and 2 others, but Parliament can, as needed, increase the number as well. So comparing the two, obviously, it's not an exact parallel, and they're 2 different institutions trying to do 2 different things. But the base model of the Constitution setting up the foundations for the institution, and then Parliament being able to fill in the detail and adapt that detail over time, is reasonably well established in our system as it goes. So what's currently proposed is that this voice would be established, and that Parliament would then create some kind of model which would involve, for one, consultation with First Nations peoples about how they would like to select their representatives. That's a really important part of the process. But broadly, the idea would be that the voice would be able to offer representation, so comment, basically, to Parliament and the government on matters that affect First Nations people. So providing Indigenous perspectives, adding a new mechanism for grassroots feedback on government policy that's affecting First Nations people. And when we think about the context of closing the gap and differences in outcomes for Indigenous and non-Indigenous Australians, one of the things from a policy perspective that we see over time is that the policies that are adopted to try and address that gap are often very top-down and don't take into account First Nations people's ideas on the ground about what might be a better option or what might work. And so broadly, what this model aims to achieve is to provide a mechanism for doing that without necessarily needing to pack all of that detail into the Constitution itself. We don't necessarily need the daily operating schedules included in the referendum proposal in order for it to make sense and be able to work. So in terms of the process itself, Australian voters, and that's everyone, it's voting in a referendum is compulsory, just like in voting in an election. And they'll have the chance to approve or reject the proposed amendment. So on the ballot paper, they'll get the question. There's this proposed law to alter the Constitution to recognise First Peoples of Australia. Do you approve this proposed alteration? And then there'll be a copy of the text that I've just provided you outlining what the proposal is. And people will either be able to write yes or they'll be able to write no. Now, you'll recall from the earlier lecture that Section 128 provides this provision for a double majority in order to change the Constitution. And so what that would mean is that across the country as a whole, a majority, so 50.1% of voters would need to say yes to the change. And so that includes the population from the Northern Territory and ACT in that total. But then on top of that, a majority of voters in 4 out of the 6 states would also need to approve that proposal in order for it to succeed. And as we discussed in the previous video, that's a very high bar. That's a difficult threshold. And so what we're likely to see, and you may have seen this already, is a really key focus on several states in particular. And I'm hesitant, at the time of recording, there haven't been a huge number of polls that really aim to be representative at the state level. Most of it is just nationally representative. And so there's a reasonably good, or as good as you could expect, indication of where the votes are at across the country as a whole. So that's sort of first criterion. But in terms of assessing whether there would be a majority support in 4 out of the 6 states, you'd actually need a different sampling method in order to get representative results. And to date, there hasn't been a lot of polling done. Maybe by the time you're watching this video, there might be some clearer results on that front. But the very early polling seems to suggest, and there's huge caveats there because the methodology's not been amazing so far, but seems to suggest that there's enough support or majority support in New South Wales and Victoria, but in Western Australia and Queensland, the support is not as high. And that's a historically, Western Australia and Queensland have been hesitant about changing the constitution. So that's not in itself that surprising. But what it does mean is that focusing on that 4 out of the 6 requirement, that South Australia and Tasmania are going to be really, really key states, and you expect to see a lot of the discussion over the next few weeks really focused in those areas. And obviously the discussion is trying to persuade people right around the country, and very rightly so, helping inform everyone to make a vote. But South Australia and Tasmania are shaping up to be really key states, because in order to get that 4 out of the 6, it seems likely that both of those states would need to approve the vote, in addition to New South Wales and Victoria. But as I said, that's early days polling. Over the next few weeks, that could end up being very wrong. Western Australia and Queensland might end up being huge supporters of the voice. We'll just have to wait and see. But in terms of the campaign itself, there's a recognition that most Australians don't know a whole lot about the Constitution. And now, having had the benefit of studying the Constitution at a tertiary level, you've hopefully got a higher than average understanding of the Constitution. But there is a recognition that constitutional literacy across the broad population is probably not as high as it could be. And so one of the important sort of public aspects of the referendum campaign is the production of yes and no pamphlets. And the idea here is to inform people of what the proposed change is and what the potential consequences might be, so that they can make an informed decision about whether to vote yes or no. That's the idea in theory. The difficulty with this campaign is that the official pamphlets were written by politicians who chose to vote yes or no to the bill instigating the referendum. And it's just, it gets all the Australian Electoral Commission packaging, and it's distributed by the Electoral Commission, but it isn't actually fact-checked or independently verified by the AEC or indeed anyone. And so what you get in practice is yes and no pamphlets that are designed to persuade rather than inform. And so what that means in practice is that you've got claims that are not necessarily true or not necessarily factual being made in these pamphlets, which is a real shame, because I think that there is a real opportunity for people to be better informed about what the proposal is and what the potential benefits are and what the potential risks are. But that's not something that's necessarily being provided by those official campaigns. What you can do, if you want to read more, I've provided 2 links from the Voice Legal Literacy Project, where they have actually gone through and provided a more independent fact-checking of the claims made by the yes and no campaigns. And so that's an important resource that I strongly recommend that people take advantage of. In addition, thinking about the campaign more broadly, we are really in uncharted territory here, in the sense that we haven't had a referendum in Australia where the campaigning has been done with the addition of social media and all the technological developments that we've seen in the last 2 decades, right? So remembering that the last referendum was in 1999, the internet was very different from what it is now. And the experience from other jurisdictions, you think about something like Brexit, there is a, a lot more opportunity for misinformation and disinformation. There is a lot more opportunity for unverified and simply untrue claims to be made through social media. There's obviously a real opportunity with social media as well for people to learn more and to share ideas. And in an ideal world, social media would be a fantastic place for people to discuss the voice and learn more about it. But in practice, we know that that that's not how it plays out. And so a lot of the traditional ideas and adages about how referendums work and how referendum campaigns play out don't necessarily hold up anymore. We'll just have to wait and see. But there's no doubt that the new technologies that have emerged in the past few decades play an interesting role in the way that this campaign will unfold and the way that people's views on the voice will be shaped in the coming weeks. So that's something to keep an eye on as well. In terms of why might you want to vote yes, and then we'll also talk about why might you want to vote no. Again, I'd encourage you to look at the Voice Legal Literacy Project. They provide a much more comprehensive summary of the yes and the no arguments, and the goal is to provide advice is the wrong word, information that is as independent as possible. Obviously, everyone has their own views and perspectives, and that's completely fine. But the idea here is to present the arguments for and against in a way that's in as good faith as possible. So why might you want to vote yes? What the Voice aims to do is provide a process for listening to First Nations people. The evidence from Closing the Gap and innumerable other studies shows that policymaking in relation to First Nations people has not always had their best interests at heart, or has not always considered their own unique perspectives that First Nations people will bring to policymaking that is about them. And so what the Voice does is it introduces a new mechanism to account for those perspectives and to ensure that the government is able to make better policy as a result of having better information. What the Voice does that's different from previous advisory bodies is that including it in the Constitution gives it a stronger degree of independence from government, and it gives it more certainty. It can be more frank and fearless in the advice that it gives government, because it doesn't have to worry so much on, if we offend the Prime Minister, maybe they'll just can the whole thing. So there's that element to it. And then over time, that certainty will also create more opportunities for institutional memory and for longer term vision and longer term policy making, which would all be good things. There's an element of introducing the Voice that also comes down to respect for First Nations people. It's an acknowledgement that they are Australia's first peoples, and that there is a special and deep connection that First Nations people have with this country, and that it's proper that our founding document, or the document that establishes our legal system and political systems, should acknowledge that connection and that role. Additionally, there's a symbolic value in the sense that because the Constitution is such an important document, including the First Nations Voice conveys that special status that the Constitution has, and communicates that the Voice is a serious and important institution that needs to be acknowledged and respected. What's important about the Voice and the symbolism of including it in the Constitution is that it's not just purely a symbolic gesture, right? It's not like the previous idea of including a preamble where the change is purely symbolic. The idea is that this would also do something of substance to improve government decision making and policy making. And then the last point is around equality and the recognition that Aboriginal and Torres Strait Islanders face inequalities that non-Indigenous Australians don't, and that in order for people to have equal opportunities, sometimes there does need to be differences in treatment. And so the idea is that the voice would improve policy making in on Indigenous issues, which has historically not been handled well, in order to level the playing field and make things fairer for everyone. What about the no side? Why might you vote no? Again, the Voice Legal Literacy Project has got some great ideas and some great analysis of these ideas. And very broadly, there's three reasons why someone might vote no. The first is that they don't know and they're uncertain. And there's this old adage in referendum campaigns: if you don't know, vote no. I think the better approach is if you don't know, learn. And so that's why I'm pointing to the Legal Literacy Project as a really good resource to become better informed. But undoubtedly, across the population as a whole, there will be a cohort of people who have engaged with this issue, don't know what it's about, and as a result are uncertain and will vote no as a consequence. Beyond that, there will be a group of people who argue that the proposed voice goes too far. It's too big a change. It tries to do too many things. It introduces something new, and that's not a good thing. Or there will also be a group of people who think that it doesn't go far enough. They'll point to the fact that the voice doesn't actually introduce any new rights for First Nations peoples. The voice itself, while it can make representations to government, there's no guarantee that government has to listen to those representations. And so there'll also be a camp of people who say that the voice as it's currently provided doesn't do enough. So you get these kind of interesting extremes in the no camp and unlikely allies campaigning against the voice. Broadly, in terms of the specific arguments, there's a suggestion that while the voice itself might be a good idea, it doesn't need to be included in the Constitution. That establishing a voice could be done just through legislative reform on its own. And the argument there is, well, we can achieve the same effect without necessarily having to change the Constitution. I think to that, the Yes campaign would probably respond with those points I raised earlier around the certainty and the longevity that constitutional inclusion provides are benefits that pure legislation couldn't achieve, but it's the argument that's made. There's also a concern that inclusion of the voice in the Constitution would prejudice First Nations people's ability to create a treaty or would be an acquiescence by First Nations people to colonial power, basically, by including this institution in a colonial Western document. There's a fear that would involve giving up First Nations people's sovereignty and the potential for entering into a treaty down the track. And there have been arguments about whether that's the case or not, but there's been that's one of the concerns that have been raised on the no side. There are discussions about fairness and whether it's fair to single out First Nations people and have a representative body or an advisory body that seeks to represent First Nations views, whether it's fair to include that in the Constitution but not have similar bodies for other groups, whether that's the population at large or other minorities as well. There's also an argument around race in the sense that it's not right to make a distinction between First Nations people and non-Indigenous Australians. The argument is that we should all just be considered Australians under the Constitution, and that the Constitution should apply to everyone equally. I think, having studied constitutional law over the past 12 weeks, you may take your own view on that issue. And then the last concern is that it's too risky, that the uncertainty or the details which Parliament will be able to fill in later, there's too much that isn't included in the current proposal that introduces uncertainty, and where there's uncertainty, there's risk. There's risk that the voice would be subject to litigation. There's risk that the body that ends up getting established is not something that aligns with the view or the vision that's currently put forward, and so there's the view or the argument that there's too much uncertainty at the moment. We better not risk it, and we'll vote no. And so that's a summary of the yes and no arguments. Of course, everyone's entitled to their opinion, and I would encourage everyone before the 14th of October to do their own research, make their own inquiries, and make up their own minds about whether to approve or support the change. That's if you do want more information, I've plugged the Voice Legal Literacy Project a fair bit. That's their homepage on screen now. You are more than welcome to check that out. They've got a lot of great resources on more of the background, more analysis of the yes and no campaigns and the yes and no pamphlets, more detail on what's proposed and how the voice might work in practice. So absolutely feel free to check it out. We will leave it there. Thank you all very much for listening to this bonus lecture. And yeah, all the best in your studies, and all the best on October 14th. Thank you very much.